IVM.
Aadhaar has been judged. The Supreme Court of India has delivered a set of judgments on a host of issues related to India's unique ID project. Rahul Mutton and Mansa Venkatraman break down the judgment and its implications on this episode of the Pragati Podcast.
Welcome to the Pragati Podcast, a weekly talk show on public policy, economics, and international relations. We are your hosts, Hamsini Hariharan
and Pavan Srinath. On the 26th of September 2018, a 5-judge bench adjudicated on Aadhaar and published a set of judgments in a 1,400-plus page document. The bench comprised of the Chief Justice of India, Deepak Mishra, and Justices A.K. Sikri, A.M. Khanwilkar, D.Y. Chandrachud, and Ashok Bhushan. To analyze this verdict, Rahul Mutton and Mansa Venkatraman returned to the Pragati Podcast. Rahul Mutton is a partner at Trilegal, a fellow at the Takshashila Institution, and the author of Privacy 3.0. Do check out episodes 53 and 54 of the Pragati Podcast, where Rahul talks about the evolution of privacy and how we can think about data and privacy in the 21st century. Mansa Venkatraman is my colleague and associate fellow at the Takshashila Institution. Mansa is a lawyer by training and has spent the last year and a half researching and writing extensively on data protection and governance in India. Mansa was here last on episode 55 to talk about some of the same. A couple of disclosures before we get on with the show. Rahul's firm Trilegal has represented various private sector companies that use Aadhaar in the Aadhaar case. Further, Nandan Nilekani, the first chairman of UIDAI, has been a donor to the Takshashila Institution in the past. We'll be back with Rahul and Mansa after this short break.
Hey, it's been another great week on IVM Podcast. If you're not following us on social media, please do. We're IVM Podcast on Twitter, Facebook, and Instagram. Also, please do spread the word about podcasting. You are our biggest ambassadors. If you tell somebody to listen to a podcast, that is the way that we're going to grow this space. This week on Simplified, the Simplified gang breaks down the funda of oil prices and why India pays so much for fuel. This week on Cyrus Says, Cyrus is joined by writer and film personality Raj Grover. He regales us with stories from partition and the heyday of Indian cinema of the 50s and 60s. On the Pragati Podcast, Pavan and Hamsini discuss the government regulations that make the lives of restaurateurs difficult in Bangalore. They've got a really special guest. Manu Chandra is on that along with Madhu Menon. This week on IVM Likes, IVM staffers Janam, Abbas and Surbi sit down and talk about movies that didn't live up to the hype. Last week, the Rediscovery Podcast went live with their 4th season. Listen to the first episode as Ambika and Hoshna talk about quitting their jobs for traveling and is it for everyone. On Shunya 1 this week, Shiladitya and I speak to Sairi Chahal. She's the founder of Sheroes, which is India's largest online community for women. This was another really, really interesting talk. And with that, let's get you on with your show.
Welcome back. Hi Rahul. Hi Mansa. Welcome back to the Pragati Podcast.
Thank you.
Aadhaar as an idea has been around since 2006. The UIDAI was set up in January 2009 and the first unique ID was issued later that year. And the Aadhaar Act was passed by the Parliament in 2016. Cut to 26 September 2018, where we have a judgment coming from the Supreme Court on various things around the Aadhaar, not just the Aadhaar Act, but other amendments and provisions that have happened elsewhere in the government. Aadhaar has played a role over the last few years in many, many parts of our individual lives, from banking to linkage to telecom to use while filing our taxes and so on. So I want to take time today on this episode to talk to you about what the judgments have said. And we should remember that all of this is coming in after the Supreme Court has declared that Indians do have a right to privacy. So we will talk about that a little as well. But I think the first place to start is that in 2016, when the Aadhaar Act got passed, it was passed as a money bill. And I think that's one of the things that the judgment discusses. So Rahul, could you tell us a little about what the challenge is with Aadhaar Act being passed as a money bill, why it should have been, shouldn't have been, and what the Supreme Court has said?
So to answer that question, I think let's go back to the types of legislation that you can pass. There are essentially 3 types of bills. There is the ordinary bill, there is the financial bill, and there's the money bill. And as you know, we're a bicameral legislature. So any legislation needs to pass through both houses of parliament. The only exception is the money bill, which has to be initiated in the Lok Sabha, does get referred to the Rajya Sabha, but does not require the Rajya Sabha to give assent. And if it doesn't provide its assent in a period of 14 days, the bill comes back to the Lok Sabha and the Lok Sabha can pass it.
So this is why if a money bill fails, that means that the government has failed. Right?
Correct.
So it's a big thing. So that's how our budgets also work.
Correct.
So we don't have a government shutdown the way the United States has a shutdown, because the government of the day has the power to push through a budget and important money bills.
But the point is that the money bill and what is defined as a money bill is actually quite narrowly limited. And so it is essentially for incomes and expenditures in and out of the consolidated fund. Therefore, the nature of money bill legislation, it has a government focus. It's used for subsidies. It's used for various other such expenditures out of the government. And I think even in the beginning, when the Aadhaar scheme was passed as a money bill, there were some questions raised as to whether this is the appropriate way in which to pass it. Of course, there was an attempt to pass a enabling legislation for the Aadhaar scheme even before that, under the UPA government. And that went through the regular process, which was going to go through two houses of parliament. It got stalled at the standing committee. Yashwant Sinha was the head of the standing committee at that point in time, and we know that whole discussion and what happened there. So the fact that it was passed as a money bill was one of the significant grounds of challenge to the validity of the Aadhaar Act itself. And in order to rule on Aadhaar, the Supreme Court had to first deal with this challenge as to whether it could validly be passed as a money bill. Now, one of the provisions in Article 110.3 actually, says that the final word as to whether a bill can be provided the certificate of a money bill or not is the Speaker's, which seems to imply that all it takes is for the Speaker to say, yes, this is a money bill, and no one can question that. And of course, that was one of the first hurdles that the petitioner had to get over when they brought the challenge. Now, the ultimate decision of the majority is that the Aadhaar Act is validly passed as a money bill. They base that on this concept of the heart of the legislation. So they said that a bill is a money bill as long as at its heart it has this sort of a government/subsidy purpose. And they found the heart of the Aadhaar Act in Section 7, which talks about the use of Aadhaar and specifically talks about the use of Aadhaar for subsidies and similar kind of government schemes. And
so there it's Aadhaar as a method of identification of a beneficiary of a government scheme of some sort.
Correct.
Where they're given certain subsidies or provisions through Aadhaar rather than through some old ration card system or some other system.
Correct. And 7 speaks largely of government uses. So the Supreme Court says, if you look at 7, 7 is the heart. There are many other provisions, but they're all incidental to the heart. And so as long as the heart bears the characteristic of a money bill, we think that this is okay as a money bill. Chandrachud disagrees. Chandrachud has the lone dissent of the 5 judges. And in fact, his entire dissent is based on the fact that this law has been passed improperly as a money bill. And he says that, this is, in a sense, he says it makes a travesty of the fact that we are a bicameral house if one house can pass a law which doesn't bear the characteristics of a money bill as a money bill, because then they could do this and never ever consult the upper house or the other house for it. And so, of course, he goes through a lot of the detail of all of the other grounds of challenge, but the strongest opposition that he expresses to the Aadhaar Act is the way in which it was passed as a money bill.
So to give a little more context to what Rahul has already said. Article 110 of the Constitution says 7 kinds of bills can be money bills. And it's very important because it says only these 7 categories of bills classify as money bills. Now, A to G are the different categories of bills that come under money bills. And a few of them talk about, one of them says subsidies, one of them deals with taxes. But like Rahul said, most of them deal with the movement of funds in and out of the Consolidated Fund of India. A to F lists out all of this. And G, which is the 7th kind of money bill, says any other matter that is incidental to these 6 things will also be a money bill. So the justification of the majority in the Aadhaar judgment seems to be that although Section 7 is the only material section that has the meat of, what has to constitute a money bill, the rest of the Act is incidental to this section, wouldn't have survived without this section. And for this reason, the whole Act is a money bill.
I agree. I think I should have mentioned that. The point on only is something that they spent some time on in the judgment. And Chandrachud says that since they use the word only, you absolutely cannot expand the scope. It has to be used very narrowly in the context of all the others that preceded. And so you can't just, bring anything in to a money bill, which, in many ways I agree with that articulation. And I think it's a dangerous precedent to expand the scope of what is a money bill. Because once you do that, then you're just opening the door for all sorts of legislation to squeak in through one house of parliament. And that's just not the way our legislative wing is designed.
I forget who said this first, but democracy functions around taboos, where, there are various parts of government and they all have certain power and certain discretion as well. And democracies work well when certain taboos are not broken. So I concur with your fear that if this taboo of the use of the money bill has been broken once, it can be broken again by a different government, by a different political party, to achieve whatever end they have, right? And the means cannot justify the ends, especially in a constitutional democracy like ours. But I had a follow-up question, which is that, you were talking about how the judges were interpreting this question of whether it's a money bill or not. But if the speaker has the final say, then was the question that the judges can overrule what the speaker said? How did they discuss this?
It's an interesting question. I think, Chandrachud goes into it in the most detail in his dissent. And he says that despite Article 110.3 that speaks about the fact that the speaker has the final word, there has to be judicial review inbuilt into everything, because just that's the nature of the checks and balances between the various legs of the government. I don't think any of the judges actually dispute that, because they all go into some detail to justify this. It's just that Chandrachud is the only one who comes out with a view which says that, after the judicial review, we think that this is not a money bill. The others, in many ways, went through that whole discussion and agreed with what the speaker said. And so it became a moot point as to whether the speaker had the final word or they had the final word. They just said, we're not going to disturb that particular part of the challenge.
So if, say, the money bill is used again for something that is not quite a money bill, the judiciary can step in and use perhaps this as a precedent to review the bill again, right?
I think a large part of why Chandrachud spent so much time going through this is to lay the groundwork for something like that.
Fair enough.
Even though it is a dissent, I think some of the articulation that he's done, and he spent some time actually going into the case law to establish the court's right to review, I think that will be useful if this happens again.
Do you think that's desirable? So I'll expand my question a little bit more. I know that all laws that are passed by our parliament or by state legislatures are subject to judicial review after they've come into being. So the courts can go back and declare them unconstitutional. But hasn't it always been a part of our parliamentary tradition to leave what happens inside the legislature outside the scope of courts' review? And, changing this narrative so deeply, do you think it would have undesirable consequences going forward?
So, if you look at our constitutional history, we've always said that there is a separation between the executive, legislature, and the judiciary. But ever since the basic structure doctrine came out, the judiciary has said, look, you do have the power of amendment, but you can't amend the basic structure of the Constitution. So if you draw from that analogy where there is an absolute power of amendment with the legislature, and the judiciary says, I don't think you can exercise that absolute power to excise me out of the scheme of things. And if you flow that analogy down to this as well, it's in many ways it's very similar, to the whole Keshanand Bharati concept. But I think it bears some logical reasoning. It bears some thought to actually say that if we've got a set of 7 provisions that constitute a money bill, and someone has been given the discretion to say yes, it falls within the 7. Our system of government actually requires another person to sit in judgment. So we work with 2 pairs of eyes. So what the legislature does, the judiciary can look at. And if there is a decision that is taken which is beyond review, then we are actually concentrating too much hands into one leg of the government, or one functionary of one leg of the government. And that is not the way our system is set up. So, I think this is a difficult technicality. We've sort of gone down a bit of a rabbit hole on this.
Absolutely. But, there's also the question of, is the speaker a person who owes their ultimate allegiance to the legislature, or since the executive or the government of the day and that political party has had a greater say in appointing the speaker, so there is that sort of moral question, if not a legal question as well, right? So anyway, this is an important topic, but I'm glad that we got this clarity. So they have approved the bill, but the judiciary has stepped in. At least the dissent judgment has sort of looked at this topic. Now let's get to things that there is more apparent concern and demand about, right? What the Aadhaar means for anyone who wants to pay income tax, anyone who gets a subsidy, anyone who wants to use government services, and so on. So let's go through them one by one, and do tell us about what the judgment says. So the first thing, government's use of Aadhaar for delivering subsidies. This is now considered legal.
Yes, and I don't think the challenge was whether the government could use it. I think the challenge was essentially on points like exclusion,
right.
And does the technology result in some sort of exclusion,
right.
and things like that. And the majority considers this and is at pains to say that we have considered all the exclusion arguments. I think they say that the 0.23% that have been excluded, we believe that there is certainly that shouldn't happen, and that we should find ways in which they're not excluded. But the fact that 0.23% have been excluded is not grounds enough for us to strike down the entire scheme and deprive the remaining 99% of the benefits that they could and are receiving out of it.
So improving our subsidy regime even further is back in the court of the government. It's
Yes.
their job to include the excluded.
Well, I think they make it clear that you can't exclude anyone. So you've got to, you have technology, and technology may be an evolving thing, and all that's all very well, but in the process, you can't exclude anyone. And to be honest, the government also issued a circular saying that no one can be excluded just because their Aadhaar is not working. All of this predates the judgment, and I think the judges refer to all of that and say, look, the circular exists and there should be no exclusion.
All right.
That's easier said than done, because as things work on the field, sometimes there is exclusion. But I think the more important point is that the government, that the judges are quite emphatic in their statement that the exclusion of the 0.23 is not grounds for striking the whole thing down. I don't think they go so far as to enumerate the benefits of the 99.7, but they certainly do say that we are clear that this is not grounds for striking it down.
But to me, one part is subsidy. I am receiving something from the government. I'm a beneficiary, and therefore earlier I had to get a ration card to access a particular benefit from the government. Today, so therefore somebody has to enroll for Aadhaar and use Aadhaar authentication to get those subsidies. What about the other end, where I as a citizen am paying taxes? I still need to link my Aadhaar to my PAN card while paying and use it to pay taxes?
Yes. The amendment to the Income Tax Act 139AA, which required Aadhaar linkage with the PAN card, has been affirmed.
Okay.
And so, the majority quite clearly says that it needs to be linked.
Is there a natural law justification for this? Why should I link this while paying? Why should I link my biometrics while paying taxes to the government?
I want to stretch that question a little further for the purposes of this debate. The objective of the Aadhaar Act is to ensure more efficient distribution of subsidies. So a person who has an Aadhaar number is entitled to receive these subsidies more easily because, it's a spiffy process. But on the other end, like Pawan said, there's an obligation for me when I'm paying my taxes to have already enrolled for an Aadhaar card on the basis of which my taxes will now be filed. If it's a money bill under one of the sub-articles in 110, which it is because it's a subsidies bill, then how can it be extended to taxes?
So the logic of the majority is that, and they cite the numbers that were provided to them by the government, and they say that that 33,000 crores, I think there's some significant number, and maybe I need to check that number specifically, but a significant number of people plus a amount of money plus about 1.1 lakh PAN cards that were duplicate PAN cards have been weeded out of the system. So I think what they cite is that there is a need to try and prevent people from getting out of the tax system when they actually should, which is a requirement from a proper collection of tax and a proper functioning of the financial system of
and
the
there's
government.
a horizontal equity issue as well.
And there's a horizontal equity issue. I mean, ultimately, what they did was, because this is the first instance after the 9-judge Puttaswamy judgment, where legislation or a series of laws are being tested against the threefold test that they laid down in Puttaswamy. And so the threefold test, just to quickly recapitulate, is that the government can only invade someone's privacy if there is a law. That law needs to articulate a state need, and whatever the law does by way of invading privacy needs to be proportionate to the need. And they had to test it against all these three. Now, 139AA is a law. There is, they said, a need, because the need as they articulated it was that there is this loss of revenue to the government because people were using sort of multiple PAN cards and things like that. And then they believed that just linking the Aadhaar to this would allow you, I mean, it's a simple mechanism to prevent you, you can only link one Aadhaar to one PAN card. And if you've got 5 PAN cards, then the other 4 can't be used anymore. And they believe that this is a proportionate means to achieve that state need. And so the majority upholds 139. That is the majority of the 3 judges, as well as Justice Bhushan, who also upholds it. Chandrachud, interestingly, actually just says that Aadhaar itself, since it was enacted as a money bill, is unconstitutional. And so there is no question of linking the PAN card to something which is unconstitutional. He doesn't go into, in the same degree of detail that he does in with regard to the other acts, into the threefold test, when it comes to the 139AA amendment. So in a sense, if you keep for a moment Justice Chandrachud's objection overall to the money bill, this is almost as close as you will get to a unanimous approval of the PAN linking. And I think it's quite clear that all of us who are tax-paying citizens and have not yet gotten Aadhaar or linked our Aadhaar, we have, I think, till the end of the year, financial year, to do that.
Okay. So even if you're availing no subsidy from the government of India, we still need it if we want to pay our taxes. And that's not a choice, really.
It should be a choice.
And when we need to pay our taxes. Yeah. Let me say that. All right. We'll be back with Rahul and Mansa after this short break.
How aware do you think you are of your laws and rights? Do you look up to laws when you are caught up in situations? Do you know what your rights are when you're stuck somewhere bad? Well, here's a show that can help you move an inch closer to being aware of what your rights are. Tune into Know Your Qanoon with me, Amber Rana. This is a podcast meant to answer all your law-related queries. Catch Know Your Qanoon every week on the IVM website or the app or anywhere you get your podcast from.
Welcome back. So let's talk about some of the other things that have been contested in this. Linking our Aadhaar numbers to the bank accounts. Where does the judgment stand on that?
So the bank account linking has been struck down. So the bank account linking was through the PMLA amendments, and essentially what they said
this is what the Prevention of Money Laundering Act.
Correct. And so what they said was that, and once again, the PMLA amendments were tested against the threefold test, and I think it fell short on the proportionality ground. One striking articulation of this is, as the majority said, the consequence of not linking within a specified period of time, and that's really what the circular says, was that your account would be frozen. Now, so the alleged state need was that we need to curb money lending, we need to curb movement of funds that we can't track, and so if we link an Aadhaar to it, we would be able to identify the individual. But by having a provision which results in anyone who doesn't link his Aadhaar to his bank account having their assets frozen, their financial assets frozen, that the court felt was not proportionate at all, because it presumes criminality on everyone in a very disproportionate manner. So I think that also, there is full unanimity on including the ground, which is the proportionality ground. Even Chandrachud goes into it in some detail. So the PMLA amendments, the linking to bank accounts in the current way has definitely been struck down. Now, it is possible that the government for all of these things can come up with a new law, or can come up with a new set of provisions and a new scheme under which this will be done. Once again, all of that will be tested against the threefold test. And more importantly, since the Aadhaar bench has actually gone into this in some detail, it will also be tested against some of the principles that have been laid down in this Aadhaar judgment.
Help me walk through this. So we have a draft data protection a bill that's been tabled in Parliament, right? Where there's a whole bunch of things. We discussed some of this in past episodes with both of you. So, and we have the Puttaswamy judgment conferring the right to privacy to all of us. So supposing there's a new Prevention of Money Laundering Act where you don't freeze your bank account, but some other action is taken, or government, keeps a tab on it or something. Can the government go ahead and do this? Will there be automatic judicial review? Will someone have to file a PIL or something to put something under judicial review? How does that work?
So typically you have to file. I mean, it is possible, and it happened in the early days of PIL, that the Supreme Court would take suo moto cognizance of something, or you send a postcard in. That's the classic early PIL story. And the Supreme Court would take cognizance of it. That doesn't happen now. You have to file.
But there are enough people waiting to file.
Yeah, I mean, in the current environment, I think we've got a clear precedent. We've got clear logic. Unless it is something which is well thought through, I think it will certainly be challenged.
So at least over time, government will have to internalize some of those rules while formulating a law, and then provide the necessary reasoning, so that even if someone wants to challenge it in court, the bar will be quite high for the Supreme Court to even take.
Well, I mean, I think there is a balance that has now come about. You got to understand that the Puttaswamy judgment, the 9-judge bench, essentially happened after all of these things were introduced, and so to be fair to the government, I think going forward, if they legislate on something, they will certainly look at Puttaswamy, look at all the Aadhaar case and all of this, and draft something within those contours, because the government really doesn't want, I don't think, wants to enact things to have them struck down all the time, right? So once they've got, they didn't until Puttaswamy have the guardrails within which they were required to enact things. Now that they do, I think they certainly will.
No government wants to waste its time on legislature which will get killed a year or two later, because they spend a lot of political capital trying to pass, trying to make a bill, a law, trying to even draft that bill in the first place, right? So and fair enough.
If anything, the one of the other good things the majority judgment in this case does is, just for proportionality alone, it gives a fourfold test. So will it cause undue inconvenience, intrusion to the individual, to the subject of the law? Is it absolutely necessary? Is it a reasonable extension of what was mandated by the law? So these kind of considerations will also hopefully be computed into legislation.
So in that sense, the interpretation of what privacy means for each and every Indian is being read more and more deeply.
Correct. So you had the threefold test, the third leg of which is proportionality, and in this judgment, they said that there are 4 sublegs of proportionality.
So there is 3A, 3B, 3C, 3D.
Exactly. And that's good, because we, all of us like some structure. And if we know exactly what are the things to test on proportionality, when we enact a new law, we will keep that in mind.
So all of this is happening pretty much for the first time in India, right? In that sense, all these 3A to 3D in a sense.
Yeah.
And
so, so the 9-judge Puttaswamy judgment is extremely powerful. You got to understand that it validated 40 years of jurisprudence, which was based on shaky foundations. I think we went over this in the previous podcast when we spoke about the evolution of privacy in India. So, and that just happened last year. And then now the Aadhaar judgment testing itself against the Puttaswamy threefold test is the necessary second step in judicial evolution, because the Puttaswamy judgment was completely conceptual and theoretical. They didn't go down to actually speaking about Aadhaar and how all of this would apply to Aadhaar. They referred to it in very conceptual terms. This judgment takes all of those conceptual terms, it takes all these various challenged, impugned legislations, holds it up against that, and then says this is the way in which these will be held valid or not. This is how the threefold test will apply in this context. When they get to proportionality, they say we need a little more clarity on proportionality, so let's talk about these other 4 things. And that's the way we get more clarity. We've always had a nebulous concept of privacy. Now I think we're getting the contours quite clear.
I'll tell you, the first time when people said, oh, there's a right to privacy being read into the Constitution is a landmark judgment, I didn't quite know what that landmark meant for a bit. It took time, but this is what a landmark judgment means, right? That because that landmark judgment was made, 377 being struck down happened more readily, Aadhaar was examined more carefully, and we will have this going forward. So the repercussions and the implications of a judgment are very large. Its footprint is very large. So
particularly this judgment, because they don't stop at just privacy. They go into things like 377. They go into various other freedom of choice kind of things, and there will be many repercussions of this in the years to come.
And many of our laws and our systems of governance will finally sort of enter the 21st century because of some of those repercussions.
Yeah, but as I said, it's not like we haven't had a concept of privacy or the right to privacy. We've had this for 40 years. It's just that it was built on shaky foundations, and now that it's all been clarified, and also at the time that the 9-judge bench happened, there were a number of these sorts of issues that were at top of mind. 377 had been decriminalized by the High Court. It came up to the Supreme Court and it was recriminalized. And then we're talking about privacy. And then part of the reason why it had been recriminalized was that the privacy of a small minority, the Supreme Court felt was not relevant. Yeah, and so in that whole environment, this came up. And so, yes, that's the reason why it became a landmark judgment. It's not landmark because it's the first time a right of privacy was articulated, right? We've had a right of privacy in the jurisprudence for years. It's landmark because of all of these other things that it did, and just the whole breadth of it. And, you have 9 judges sitting together is a very rare thing today. In the early days of the Supreme Court, I think they sat in these sorts of benches much more frequently. But now it's just unheard of. Even getting 5 of them to sit and hear the Aadhaar matter for as long as they did was quite a feat.
So this is fantastic. And okay, going forward, we talked about subsidies, taxes, bank accounts. What about our cell phones?
So cell phone linking has also been struck down. Once again, you're going over the threefold test. Essentially, they said surely the government could have found a less intrusive way of achieving whatever it is it wanted to achieve with regard to mobile phone linkage. And then there's also reference to the fact that, if you do this, you have to do it by law. And the circular that the DOT issued, they didn't feel was law, the type of law that you would need in order to strike this down.
So does that mean all other circulars that also mandated Aadhaar linkage are now going to not have effect? Because RBI mandated eKYCs through Aadhaar. The insurance, I think LIC also mandates eKYC through Aadhaar. So there's a whole host of sectoral regulators that just went ahead with this theme. What does this mean for them?
It's a troubling question for me as well, because the word law, when you understand it in this context, doesn't mean just a law which is passed through both houses of parliament. It encompasses within it a lot of other things. It's just historically supposed to encompass within it a lot of other things, including delegated legislation.
Like rules, like regulations. And in the context of the whole telecom regime, you've got to understand that we have a Telegraph Act, which is created by the British. In the era of telegraphs.
In the era of telegraphs, which is why it's called the Telegraph Act. And modern internet, and now, the new draft telecom policy is out, 5G telecommunications still derives its influence from that. So a lot of telecom law is actually articulated in policies, which don't have binding value, and in licenses. Because the licenses spell out the relationship between the licensee and the regulator, which is the DOT. Now, is a license a law? And, can you do it can you mandate linkages through the license? There's no relationship between the regulator and the cell phone user. And there isn't a scheme in the context of telecom law that will allow for the traditional types of things that get called law. And so you got to think about it slightly differently in the telecom context. Of course, the simple solution to all of this is to have a modern telecom law. I mean, why are we still stuck with the Telegraph Act that the British invented? Very cleverly, they drafted it such that the definition of the word telegraph is broad enough to cover everything that we use today. But that's surely not a good way to go. And so, just to get back to your point, Mansa, on that will circulars be covered? I would think that in some circumstances, delegated legislation and I think some forms of subordinate legislation could well be covered. But I think if we go down to things like press notes and circulars, particularly in the context of something as invasive of personal liberty as privacy, maybe the statement that the courts are making is you've got to do something better than a circular if you're going down this path. I haven't yet studied all the various Aadhaar linkages that have been done by various means, and I'm sure there are many circulars and just, I guess, internal notes and things like that based on which this is happening. It seems quite clear that they will not fly anymore. You'll need a law, and as they've elevated it to a level higher than a circular, we'll need to figure out where exactly what gets covered and what doesn't.
There are also some other provisions on, or rather there was a practice of saying use your Aadhaar number if you want to appear for the CBSE 12th board exams, for UGC exams, various other competitive exams. Use the Aadhaar number to get into
that they've
some schooling
categorically
things.
done away with.
Those things.
So the only thing they have allowed is that they've said if you're applying for a government scholarship, then the government can say, use your Aadhaar. Now, once again, that falls within the whole subsidy concept.
Exactly.
And so that fits into the scheme. They've also said that children's, you can't demand that children need to get an Aadhaar. That is entirely within the authority of the natural guardian of the child, which would be the parent. And strangely, they've also added something else, which is that if the natural guardian gets an Aadhaar for the child, when the child becomes 18, it achieves the age of majority, the child can decide to exit out of the scheme.
Okay.
There are little nuggets like this throughout the judgment, which
are very problematic in practice, right? Uh-huh.
Yeah, it's easier said than done in my mind. And I think the thing about this judgment that concerns me is these little sort of throwaway statements that may have very significant repercussions just for the whole design of the Aadhaar architecture. So just to very quickly take you through what I see as some of the complications with exiting from the system, the way Aadhaar is designed is your biometrics are captured and the image of the biometric is stored separately in a very secure archive, which is not designed to be accessed at all. The only reason why it will be accessed is if at a later point in time, another person attempts to enroll into the system and there is a match between their biometrics and yours. And then if someone physically needs to eyeball the two, a human being needs to physically eyeball the two to say that these are the same or not, that is the only time it gets pulled out of the archive. For everything else, the image is converted into data. So it's converted into a table. And that is a table that is used to match on the authentication and all of those things. So when you're exiting from the system, I think it's fairly non-trivial to delete the authentication table, which is just a set of numbers. The Aadhaar number that has been issued to you, even if you exit from the system, can't be reissued to someone else. This is not a reusable number.
Right.
And so that number has to be put into some sort of storage, and all your demographic information needs to be, I'm assuming, purged from the system. I don't know how difficult or not it will be to actually get into that secure archive and then pull out selectively some biometric images. But I'm just thinking this system was not designed to be exited out of. And if the Supreme Court is now saying that we have to allow children who become majors the option to exit, I don't know if by retrofitting that into the system, if we inadvertently create some other security challenges into the system. The point is that a lot of this is designed to be automated. But if you are pulling this out, you are allowing people to poke their nose into that part of the system that was kept highly secure and away from everyone for a reason. And we are in that sense diminishing this in some way. So, I guess maybe we need to talk to some technical experts to see how exactly that works. But it sounds to me as a problematic area.
I know that we have a personal data protection bill that we're all scrambling to comment to for the end of this month. But how do you see the Aadhaar judgment impact this bill? That's
a fabulous question. No one has asked me this yet, but I've thought about it a lot. I think so. Let's just go through the maths of it, right? We've got one session of Parliament left before the government gets into election mode, and so they just got one session of Parliament to pass a law. My hope was that when the Aadhaar judgment came out, it would require that, but for a privacy law, Aadhaar would not be valid or would have diminished value. That's not happened. So there have been many references to the need for a privacy law, and there have been many references to the fact that the Sri Krishna Committee has issued its report, that there is a draft law, so go ahead and enact it. But it's not been linked to anything in a sort of a meaningful way that would place some urgency on the government. That's the first thing. The second thing is that the Aadhaar scheme itself has been watered down. In many ways, the wings of Aadhaar have been clipped. And in this new environment, the urgency for the government to have a privacy framework that protected Aadhaar in its full vision is not there anymore. So even though we're all scrambling to send comments by the end of the month, I am now skeptical that this bill will be introduced into Parliament, or even if it is introduced into Parliament, if it will proceed in the same urgency as it would have had we had a stricter sort of provision. And I think the second thing is that the government is going to be scrambling to do whatever it takes to give effect to Aadhaar again. As I said, the wings have been clipped in many ways, and I guess we'll get to that in a bit. But that, I think, will be the focus of the government right now, more than a personal data protection bill. If it doesn't get through in this session of Parliament, then if the government comes back and it's the same government in power, then there's a good chance that they may continue to process the bill and get it passed. If it is the NDA but with a different configuration, I don't know what will happen. If it is not the NDA, the UPA, for example, I don't even know if the UPA will accept this committee report. They may create yet another committee. I mean, we've had 2 committees already. I don't see why we can't have another committee now. And then we'll see what happens. So if we don't get it done in by February, March, I think we're going to have to wait another 2 years before we have a privacy law.
But that also means that it's easier for this government before February, March to just pass amendments to the Aadhaar Act and remove the hurdles in its path.
Look, that I don't know, because the last time they did it through a money bill, and I think they've at least now learned their lesson that may not be the path to go down. I don't know. I mean, I think it's up in the air as to what exactly they will work on, if they will work on anything at all. I think this is also new. I mean, you're recording this 2 days after the judgment, and it's still sinking in to people. I think we're seeing a lot of op-eds that are written that don't seem to have got really into the meat and the depth of the matter, and there are many challenges with this, and I think it'll take a little longer to figure it out for the government to figure out what it needs to do.
We'll be back with Rahul and Mansa after this short break.
Hi, my name is Anupam Gupta. I'm B50 on Twitter. I am the host of Paisa Vaisa, the show that talks money. On my show, I speak to experts from every field of money and finance, from stock markets, equities, debt funds, credit cards, life insurance, every possible area of money and finance that you can think of. We even did an episode on cryptocurrency. I've got fantastic guests from mutual funds to personal finance experts everywhere. Robo-advisory, startups, just name it, we've got it. At Paisa Vaisa, we help you make smart decisions about money. You work hard for money. Now make your money work hard for you. New episodes out every Monday, and you can listen to my show on the IVM Podcast app or any other podcasting app that you have.
Welcome back. Rahul, what does the Aadhaar judgment say about the private use of the Aadhaar authentication network?
The Aadhaar judgment goes into Section 57. And if you take a look at the scheme of the Aadhaar Act, Section 57 is a provision which talks about other use of the Aadhaar infrastructure, and there are essentially 2 parts. One is other use by the government, and then the other portion of it is other use by private entities, and they say body corporates and private entities. Now, with regard to the first part, the judgment says very clearly that you can't have any use that is not backed by law.
Right. We discussed this with telecom as well.
Correct. So they have read into Section 57 the term backed by law, which means that if the government wants to go ahead and use it for any other use, it must first make a law, and then it can go ahead and use it for any other use. Now, as far as the second part is concerned, they mention that when the private sector collects and uses biometric and demographic information, there is a chance that they may commercially exploit it. And it's quite clear that they don't like that utilization of the Aadhaar authentication service. And so the judgment of the majority says quite clearly that that part of the provision which allows private sector access to authentication services. And they say something a little funny, which is that too by contract. And there's some confusion as to what exactly that means. But, if you park that for a moment, they say that access by private sector of the Aadhaar authentication infrastructure is unconstitutional. Now, it's difficult to fully understand what the scope of that is. In the first place, they qualified this, or they provided an explanation for this and said that this is the reason why they're holding it unconstitutional is on account of the fact that it can be commercially exploited. So I think it's quite clear that any private sector entity that is using it purely for their own commercial operation, that use seems to be declared by the Supreme Court as being unconstitutional. But the fact is that the way in which the Aadhaar infrastructure has been built out, it's been built out on a sort of PPP model, a public-private partnership model, where in order to extend to the deepest parts of the country, they have actually used a network of business correspondents and various private sector players, including, in some cases, things like Kirana stores, where deep in a village there is some person who can provide the money that is required for a subsidy or something like that, using the Aadhaar authentication system.
And this is being used to also deliver government subsidies, right? So what we talked about in Section 7 about how the Aadhaar system is all right, and it's okay for it to be used for subsidy delivery, comes into conflict with this.
I think so. And I think that really is the conflict I have in my head as to how we interpret the Supreme Court's ruling on 57. I think it's quite clear to me, as I said, that purely private commercial use is something that the Supreme Court is saying is a no-no. But I don't know if the Supreme Court is fully appreciated the fact that the Aadhaar infrastructure actually does involve a lot of private parts. There are people who are actually even involved in subsidy delivery, involved in that whole process of reaching all those things that the Supreme Court has upheld in the first part of the judgment. When it is actually implemented and when it actually reaches the people who deserve it, that infrastructure is not an entirely government-run infrastructure. There are private players in that infrastructure. There is a network of business correspondents. There is private sector banks in some cases. And I can't imagine that the Supreme Court, while it upheld the subsidy and government-related aspects of the use of Aadhaar, could have wanted to demolish the infrastructure on which that was delivered. This is an inconsistency in the judgment that I think we will need to spend a little time trying to unravel. I don't know what the answer is, but I think at this point, all we can do is point out that there does seem to be some issues with reconciling the Section 57 interpretation with the rest of the judgment, which says that Aadhaar needs to continue to be used to deliver government subsidies and benefits.
All right. This sounds interesting to me because even if you take the old PDS system, the ration shop runners were not necessarily employees of the government, right? So they would be people who would be awarded contracts to run a PDS shop, and they would deliver all these services, and then that problem would work well in certain states. It would not work well in certain states, and so on. So if technically that is the government provision of the subsidy in terms of subsidized rice, subsidized wheat and kerosene and other things, I don't see a difference in the principle between that and some private party enabling the government provision of a DBT linked to Aadhaar, right? So it seems similar to me, at least in principle.
Correct. And look, I think there's some unintended consequences that we've got to keep in mind. Everyone knows that the government is not capable of scaling infrastructure to the extent that is required. And so in various other sectors, the government has actually used the private sector to scale the infrastructure. And I think at this point in time, there are many benefits that are currently being served out on the basis of this infrastructure. If we are to say that the Supreme Court ruling is to be interpreted that infrastructure needs to be taken down, many people who are getting benefits who would otherwise not have got benefits but for this would now actually find themselves excluded from a benefit that by every other count they deserve. And I think we've got to consider the unintended consequences of that and the implications of that on the system as it currently is. I don't have an answer. I think we've got to think creatively around what the pronouncements of the Supreme Court are and try and find a way to arrive at a solution that works and upholds all parts of the Supreme Court judgment.
Even beyond this, as a person who thinks that markets can be very interesting, I find the problem with the very terms commercial exploitation. The idea that something commercial is necessarily exploitation. Even beyond this, what we talked about where private sector is a party that is working with the government to deliver certain government subsidies. The idea that the private sector can use the network and therefore not only make a profit but also provide some sort of utility to the public at large, it seems odd that it is rendered unconstitutional just in finality rather than saying, there's no law for it. Currently, it is unlawful use. So they're not saying it's unlawful, but they're saying that it's unconstitutional, right?
Yeah, that's a strong word to use. But, I have a similar pain in principle, but I don't want to second guess the Supreme Court. If the Supreme Court feels that they should not commercially exploit, I'm okay with that. I think the point I'm trying to make is that if someone is providing pipes and the pipes are carrying a subsidy and the person who's providing the pipes is actually a private sector player who I can't imagine. Of course, if by providing the pipes they extract the data and commercially exploit it, certainly that should not be allowed. And I think the government has to come up with some guardrails to prevent that from happening.
Right.
But assuming they're just providing pipes because the government doesn't have the ability to scale to reach every corner of the country in the way that they do, they should certainly be allowed to continue to do that because to not do that would drastically affect a lot of the benefits that I doubt that any one of the petitioners would have wanted for benefits that are being reaped out of the system to actually be denied to people, particularly people who otherwise would not have been able to gain access to this. And I can't imagine that it was the Supreme Court's intention to let that happen either. But we have what we have as in terms of the word that they used, unconstitutional. And I think we've got to find a way to work with that within the judgment to achieve the result that the Supreme Court wanted.
Rahul, what about the other use by the private sector of the Aadhaar authentication system? So we've had, if I'm not mistaken, the Aadhaar-enabled payment systems, and we've also had Aadhaar-enabled KYC. Right? How is that? So that's currently declared unconstitutional?
I think the direct and immediate impact would be on the financial sector. My understanding is that just Aadhaar-enabled payments alone, which is payments using the NPCI backbone directly to your Aadhaar number, and the money will eventually hit the bank account associated with the Aadhaar number. There are about 125 million people that use it, so 125 million distinct users, and there are about 150 million transactions a month. Now, the only people who would use this, and the majority of people who use this kind of transfer, AEPS transfers, are migrant workers. So people, and I think there's been some evidence that the largest corridor for APS transfers is from, say, Mumbai to Bihar. The pattern is essentially migrant workers who have moved to the city who are sending money home on a regular basis. This will no longer be possible because the money travels through the APS network, through the NPCI backbone, and ends up at business correspondents in the villages where they're intended to go. And a business correspondent could be a kirana store owner who has a business correspondent license and who will give you the money based on your Aadhaar authentication, your biometric authentication. All of that will stop. In the pre-APS world, this used to take place through essentially hawala. In Mumbai, you would give your 10,000 rupees or something like that to a person who would then find some way to carry it there or have someone there deliver it and would take a commission. And there's no guarantee that it will eventually get to your wife in the village because there could be a middleman there who would take a cut again. And all of that was eliminated through this. So, there are those sorts of issues that I think we'll have to figure out how to deal with.
Sorry, just a couple of abbreviation clarifications. The NPCI is the National Payments
Corporation
of India. This is like a consortium of...
It's a consortium of banks, but essentially what they do is all of India's digital payments run through the NPCI backbone. So, all the banks have come together as a consortium. They've agreed a protocol for exchanging of data, and this is what NEFT and all of these things run on.
Right.
UPI integrates directly into the NPCI network. So all of India's digital payments move through this, not just the things that we in cities use to wire money to each other, but even things like UPI and
Right.
payment for Swiggy or whatever it is you could do through this.
Okay, and AEPS
is Aadhaar enabled payment system.
Okay,
and so essentially what that does is that has a Aadhaar mapper. Your Aadhaar is mapped to a bank account. So it's a relatively interesting innovation, which means that you can keep changing your bank account. As long as I have your Aadhaar number, I know that my money will reach you. I only need to send it to your Aadhaar number. Otherwise you need to know the person's bank account. You need to know,
no IFSC code,
no IFSC code, no nothing, right? So then that whole headache of doing a wire is gone because whatever the bank account is that is currently linked to your Aadhaar, you will get the money. I mean, just think of use cases where life insurance is linked to the beneficiary's Aadhaar. Now, life insurance is one of those things where you've done the insurance when you're hale and hearty. You need it when you're dead, or rather, your beneficiary needs it when you're dead, and the Aadhaar never changes. So you may have moved city, you may have changed your bank account, but boom, it just goes straight to your Aadhaar and straight to your bank account. So it's an innovative solution, by and large used by the poorer segments of society for these sorts of uses. The largest use of this would be Jandan money that needs to, once it hits your account, needs to be sent somewhere else. These are the sorts of things that people would use it for. And the other thing is, and I think it's important to talk about this as well, I think the authentication and the eKYC system allowed us to do financial inclusion in a way that was not possible. And I don't want to get into the inclusion-exclusion debate because I don't think that's really relevant or material at this time. I think the benefits that eKYC brought as an alternative to the traditional paper-based KYC is a very mathematical benefit. The cost of doing KYC in the old way, which is you need to produce a document, someone needs to come and verify it, then that document needs to be taken back to head office, it needs to be stored, and then
photo proof, ID proof, address proof, XYZ proof,
multiple copies of that. You're sometimes signed against it, and then there's this contract that you have to go physically, you have to sign every page, and that has to be stored. So if you add the cost of storage, you add the cost of paper, you add the cost of having a human being actually go once or twice to the location of the borrower and pick this up and take it back. The average cost, I believe, was in the region of about 1,000 rupees. With eKYC, it came down to 15 to 20 rupees.
Wow.
Now, what this means is that obviously the amount of loan that you can offer is a function of the cost of giving the loan. Therefore, the amount
and this is a
of
transaction cost. This is nothing more.
There's nothing more you can. There's nothing you can do to avoid this. This is not interest. This is not it is not your profit on the loan.
We are not counting in percentage of defaults. None of that.
No, this is just the hard transaction cost, which could be higher or lower depending on how far you have to go and all sorts of other factors. But a rough ballpark is 1,000 rupees. That means that the value of loan that you can give is much lower now in the eKYC regime than it used to be in the paper regime. This means that people who need lower value loans are able to get them. And I think that segment of society is the segment that I guess needs it much more, and it really needs it. And if you remove eKYC and you bring back all the old costs, that segment of society that could have benefited from these innovative financial products will once again be excluded from the financial system.
I know that this is just a couple of days after the judgment, so I'm sure we'll try to get this episode out as soon as we can, and I'm sure that there'll be more interpretation and more layers of meaning that will be extracted from this 1,400 plus page judgment that has come out. Quick thing, can you tell me, if we were to edit this judgment down, how long would the judgment be to contain all the meat there is?
It depends on if you really want to read all the cases that have been cited, extracts from various past judgments. If you don't, I think about 200 pages.
Okay.
But it also depends if you want to read the reasoning that the judges employed to get to their conclusion, then it would be a little longer than 200 pages, maybe 700 or 800 pages.
No, but if I were to bring a language editor, if I were to bring a language editor in, my question is how much?
Well, I have a 800 word limit every week to generate an article. And I think I managed to do that and explain most of the issues.
And your reasoning.
So I would still stick with, 200 pages is generous. My book is 220 pages. So, I mean, the point is that there is a lot of rich detail in the judgment. And it is useful for lawyers to actually go through all of that. Sometimes this is actually reference and research material. You know that they've gone into so much detail on these issues. We go there and we look at all the cases that they've cited. We go there and look at all the international statutes that they've compared.
So like a review paper in scientific literature.
Very
right?
much so. Very much so. So it doesn't have to be like that. But that's sort of the way in which we write our judgments these days. And I think with every judgment, it's getting longer and longer. Here, each individual opinion was 500 pages, 500 pages or more.
It's about 6.5 lakh words long.
Okay.
And
wow.
I didn't do the counting, someone else did, and I'm very thankful for them for this figure, but
6.5 lakh words long. And just think about it, they did it in a relatively short period of time.
For 6.5 lakh words.
For 6.5 lakh words.
Thank you so much. Thank you, Rahul. Thank you, Mansa, for joining us on this episode of the Pragati Podcast.
My pleasure entirely.
Thank you, Pavan.
Thank you for staying with us till the end. If you listen to the Pragati Podcast on iTunes, do leave us a rating. And if you have any questions or comments, do write in to podcast@thinkpragati.com.
Thank you for staying with us till the end.
Visit our website at thinkpragati.com for your daily dose of brain fodder on all things public policy.
You can subscribe to the Pragati Podcast on the IVM Podcast app or wherever else you get your podcasts from. We're there everywhere.
Do you have a night routine? Well, everyone has one. And the to-do list usually looks like this. Brush your teeth, set that alarm, get into your pajamas, and switch off those screens. But here's one more to add to that list. Tune into the Positively Unlimited podcast for a dose of positive action and tips on how to build powerful mindsets. Episodes out every Monday on the IVM Podcast app, ivmpodcast.com, or wherever you tune into podcasts.
Have you gotten yourself a gym membership and shown up only a few times? Are long working hours cutting your fitness goals short? How about you change things a little? Even a small effort can make a big difference. And I'll tell you how and what exactly. Hi guys, I'm Coach Urmi, and on the Kinetic Living podcast, you can look forward to some interesting stories of people who have changed the way they look at fitness after their kinetic journeys. Episodes out every Wednesday on the IVM app, website, and anywhere you get your podcast from.